Hi everyone, it's Edna Kimble. I'm excited to welcome you to our podcast. Hey, hi everyone. Today we are talking real estate transactions that went poorly, specifically where a buyer ends up getting sued, which is a little bit on the unusual side. Typically, it's a seller that ends up in court. But we've recently, due to this crazy hot market, we've had some buyers come in fast and furious, make very aggressive purchase offers, and win the bid. Yay, right? Not necessarily. Sometimes buyers are not aware of the fact that they can be sued for failure to perform. And what that means is when you go into contract on a home, there is a contractual obligation. And during the first typically 10 days of the contract, the buyer does have the right to cancel the contract, walk away, and receive a full refund of their earnest money. Now, where this gets tricky is sometimes buyers misinterpret the letter of the law or the letter of the contract to mean that, okay, well, after the 10 days, if I change my mind, they can just keep my earnest money. Guys, it's not really that simple, believe it or not. So when you put the earnest money up, it is to show the seller that you're an earnest buyer and that you're going to follow the contract and do everything that you've mutually agreed to do. But the earnest money is actually to also protect the seller in the event that you fail to perform. And there's a couple of things that can happen in that situation. One, with this tight market, buyers get buyer's remorse. That's right, you came in full price, gung-ho, you locked that house down, you did the inspections, there was nothing really huge that made you want out, but maybe around the 20th or 30th day, you start thinking, maybe we overpaid for that 2-bedroom, 1-bath, and we're just going to let them keep our $500. We're going to withdraw from the contract and look elsewhere. Guys, it's not that simple. At this point, the seller may have fees also on the table, and they can sue you for their fees and costs and any monies that they've spent to stay within the contractual guidelines. So it's not as simple as you getting a release and giving them your $500 or whatever the agreed earnest money was. You can actually be taken to court and sued. Now, the good thing in Oklahoma, they can't really make you buy the home, but they can certainly make you wish you had have bought the home based upon any of their fees, their attorney fees, their real estate fees, things like that. So just make sure that you are asking the right questions and that you are choosing a realtor that's knowledgeable, has some experience in the field, and is present and answering questions as you need those answered. And hopefully even doing some education with you during the process so that none of these things sneak up on you and bite you. So again, making sure that you don't get sued and knowing that when you go into contract as a buyer, it's not as simple to get out of it as you may think. So think twice before you sign on the dotted line because it will tell you this is a binding contract. Hope that helps everyone. Thank you.